ASIC recently lost its case against Westpac in relation to alleged violations of responsible lending standards. Let's look at why ASIC lost and what it means for borrowers and for the regulator going forward. So the basic facts here are that Westpac had lent out money for home loans. As part of that lending process, the bank has to assess whether the person can afford to repay the loan. This involves looking at the person's living expenses. What the bank is supposed to do is the bank is supposed to look at the person's actual expenses and assess whether they can afford the loan accordingly. What Westpac seemingly did is Westpac estimated the minimum living expenses the person would have and assessed their repayment ability based on that. Now this gives rise to three situations. Only one of them is really relevant here. The first one is where the person's actual expenses are above the minimum. This person might be approved for a loan that they might not otherwise be approved for. The second one is where there's not much difference between the actual and minimum. Here it wouldn't make much difference to the home loan application. The third one, and this again is not really relevant here, is where the person's living expenses are below the minimum. So for example, they live very frugally. This person is going to be assessed against a higher standard than what they should be. So they wouldn't have been approved for a loan they couldn't otherwise afford. So basically only that first situation is going to be relevant, where the person's actual expenses are above the minimum. Now it turns out there are about 260,000 loans that Westpac had done over this period. About 50,000 of those involved the situation where the person's actual expenses were above the minimum. Now upon further investigation, it appears that only 5,000 of these might have been actual situations where the person couldn't really afford the loan. Put differently, in 45,000 of those situations where the person was assessed against a minimum that was below their living expenses, they could still have afforded a loan, it appears, based on the evidence. So it was 5,000 situations where they might not have been able to afford the loan. Now, it turns out that there wasn't actually much factual evidence about these 5,000 situations. So when they went ultimately to court, there wasn't enough evidence to determine whether these people could repay the loans or not. So basically neither party was really able to clarify whether these were actually irresponsible loans or whether there was a violation that gave rise to a loan that wasn't going to be able to be repaid. Put differently, ASIC didn't have the evidence at court to show that those were actually irresponsible loans, merely the fact that they'd been assessed against this minimum living expense. This is to a large extent why ASIC ultimately lost at court. The court also mentioned that there was another issue in relation to minimum living expenses. The court tacitly approved the use of that minimum living expense calculation. The reason the court did this is effectively because people might live in a slightly more ostentatious way before they have a loan. So for example, when they don't have budget constraints, people might go out and spend more when going out or on entertainment or various other things. Whereas when they have a loan, people will rein in those expenses and they'll live more frugally. This is going to give rise to a minimum living standard as being relevant in this situation. The court only really stated that minimum threshold is not really relevant if it would force the person to a poverty-like situation. But if it's someone who's just cutting back on extraneous expenses, then to some extent it can be fair enough to look at that minimum living expense to assess whether they can afford to repay the loan. So the court effectively found in Westpac's favour for two underlying reasons. Firstly, there wasn't enough evidence to demonstrate that the loans that were made out were actually irresponsible or that people couldn't afford to repay them. Secondly, in any case, when assessing these minimum living expenses, they're sometimes actually relevant enough because people can often rein in their expenses when they've got a mortgage and they decide to prioritize their money slightly differently after they have a financial burden. So that's basically what the court found. Now let's have a look at the implications for borrowers. Now the implications for borrowers aren't direct. The reason they're not direct is it's unlikely a bank is going to go out and actively just look at a minimum when they've been told to look at actual living expenses. But it does give banks some scope to look at how borrowers can rein in their expenses and use some logic and some justification and some lateral thinking to think about, well, this person is spending in this way at the moment, but once they've got a mortgage, their actual expenditures are likely to be X after they've got the mortgage. So they can laterally look at what the expenditures are logically going to be after the person has a mortgage and perhaps draws in some of the expenses that aren't necessary. So basically it gives banks a little bit more wiggle room to look at what people's expenditures are going to be after the mortgage and how they might adjust otherwise. But the banks probably won't go out and just look at a baseline minimum expenditure. They'll look at how people would logically change their expenditures as part of their responsible assessment practice. The other implication is for regulators. Now, ASIC had been told after the Royal Commission it needs to be more aggressive and pursue more litigation. To some extent you can see why, because there were claims that ASIC was a toothless tiger. The real issue, however, of course, is that when ASIC goes out and does this litigation, it conveys risk. It conveys risks in a few ways. Firstly, it's just financially expensive to pursue litigation. Secondly, it runs the risk of precedent being found against ASIC, so there might be a standard that's set that isn't in ASIC's favour. That appears to have been the case here, because ASIC had previously gone down the settlement route with Westpac. However, the settlement was ultimately rejected, and ASIC ended up taking the case to court. Now, this is a situation where ASIC rejected the settlement but lost at court. ASIC would have been better off going down that settlement route, gotten some money it could have paid out, and then not have this precedent set against it. So what does this tell us about what the regulator might want to do going forward? Well, it tells us the regulator might want to take a more collaborative and collegial approach with the banks, because this might enable it to cajole the banks and other financial institutions into going down the path that it wants, rather than pursuing litigation that it might ultimately end up losing. So to some extent it will be cheaper and a little bit more productive for ASIC to actually not go down the ultra-litigious path and try to work collaboratively with banks to achieve an outcome that is going to be beneficial both for the regulator and for customers, but also to an extent for the business practices of the banks. So it might suggest going forward that maybe ASIC needs to be a little bit more selective about the cases it takes to court, and needs to be a little bit more circumspect about whether it might be worthwhile taking on a settlement or working with a bank to achieve a particular outcome. So I hope this has given you a bit of an idea about why ASIC ultimately lost at court when it took Westpac to court, why Westpac prevailed, what it means for borrowers going forward, and what it could imply for how the regulator might approach its practice when it's approaching these banks in future situations. So I hope the video has been interesting to you. If it has, it would be great if you click the like and subscribe buttons, and I hope to see you next time.